This is really like a semester-long immigration class that I'm smashing into about an hour and 15 minutes. So I'm just focusing on the law without trying to get too political or anything like that. I'm just going to tell you what the law is. There's going to be an exception to pretty much everything I'm telling you, because immigration is actually one of the most complicated forms of law that we can practice. This is my second career in law. I previously was a trial attorney, criminal defense attorney. And I can tell you that immigration's far more complicated than criminal law. And so there's just exceptions to everything. But, you know, in the spirit of keeping it simple, we're just going to breeze through this semester-long class in an hour and 15 minutes. So let's begin. If my slideshow would move. Hold on. There we go. Okay, I'm not going to go through the whole history of our immigration laws. I actually have a whole other presentation that I might do for you all in the fall about the racial inequities in our immigration system throughout our history. But what I do want to let you know is that for the first 100 years of the founding of our nation, from the late 18th century to the late 19th century, there were no laws regarding immigration whatsoever. The only law that we had on the book was regarding who could naturalize. And up until 1943, only free white males of good moral character could naturalize. So any immigrant of color was prohibited from naturalizing. Women could only naturalize through their spouses or fathers. And in fact, they could become denaturalized if they married an immigrant of color. And then it wasn't until the late 19th century when immigrants of color started arriving in the United States, specifically from China, that the Congress started promulgating laws regarding the regulation of immigration as opposed to naturalization. So that started with the Chinese Exclusion Acts. There were 3 of them of the late 19th century. And then moving on into the early 20th century, there was more laws actually enlarging the exclusion of immigrants of color to cover all of Asia and the Middle East. And then in 1924, there were laws that were passed to try to prevent white immigrants who were considered inappropriate from coming, specifically Southern Europeans and Eastern Europeans, so Italians and Jews. My husband is Italian Jewish, so I'm glad that his family came after the laws changed in the 60s. But it wasn't really until like the civil rights era that we started chiseling away at these laws. And we finally allowed, during the Second World War, immigrants of color to naturalize in 1943. And then in 1965, we had the huge Hart-Celler Act of 1965. And that is really what I'm going to talk to you about today. That is the act that Congress passed, which basically formulated our entire current immigration system and switched it from one of being unfettered immigration for white people and immigration that barred immigrants of color to one that permitted immigrants of any nationality to come, but only through certain mechanisms. So it made it easier for an immigrant of color to get through the door, but only if they had somebody to sponsor them. And so it actually became much, much harder to immigrate for anyone, whether they were white or an immigrant of color. And all that happened in 1965. So really, what I'm going to talk to you about today really focuses on 1965. And I'm going to talk about the Act, the Code, the INA. I am referencing the Immigration and Nationality Act. That is the congressional act that is the framework for our immigration and naturalization laws. And that act breaks individuals down into 2 categories. Everyone is either a citizen or they're an alien. I'm going to use the term that is used in the code, the act, I know that now people are getting away from saying alien and using the term non-citizen. Sometimes I'll use that, but that is the actual legal word that we're using. It's still codified in the law. So we don't have in our law the words undocumented immigrant or illegal immigrant. Those are all cultural terms that have sprouted up. The law actually just puts people in two categories. You're either a US citizen or you're an alien. All right. In this presentation, I'm going to break aliens down into three categories. The first are people who are here permanently. And by that, I mean that they have a status that does not need to be renewed. They never have to leave the United States as long as they don't commit certain crimes or so forth, and they're eligible to work. Then we have aliens that are here temporarily. There are many, many different categories of temporary aliens, and I'll talk to you about some of them. But these are people that either, there's a time limit on the amount of time they can stay in the United States, or they've come only to do a certain type of work or study, or they can stay, but they have to keep renewing their status, and they may or may not be eligible to work. And then there are those who are not supposed to be here, the undocumented. All right, we're going to talk first about US citizens, and then we'll start talking about aliens. So who's a US citizen? You can become a US citizen if you're born in the United States, or if you naturalize. And naturalization is a process whereby after you've had your green card for 5 years, you can apply to become a citizen. And if you pass the test and you take the oath, then you become a citizen. Department of Homeland Security is a little behind in getting us their data. The last time I checked, they still only had 2019 data, but it's always between about 3/4 to 1 million people that naturalize every year. And also you can become a US citizen if you're born outside the US to a US citizen parent, okay? How do you, what are the benefits of being a citizen? Well, there's a lot. It is like winning the lottery. You obviously can work legally. You can travel freely without restriction, although sometimes not during a pandemic. We have all kinds of restrictions now about travel, but generally speaking, you don't need to worry about trying to get back into the United States. Obviously, you can vote. You can receive public benefits if you qualify for them. You can also sponsor certain aliens. All right, so who can US citizens sponsor? There's two categories. One is called immediate relative, and the other is called a preference category. Turning first to immediate relatives. US citizens can sponsor their parents, their spouses, and since the Supreme Court decision in 2013, that includes same-sex couples, and their children. Under the Immigration Nationality Act, a child is defined as under 21 and unmarried. So if you have an 18-year-old that's married, that would be considered a son or daughter, not a child. Or if you have an unmarried child that's 22, that's a son or daughter, not a child. But if they are unmarried under the age of 21, or your spouse or your parent, and you are a US citizen, you can sponsor them. What does immediate relative mean? It means that Congress has decided that this category of relationship is so special that there are no visa limits per fiscal year on the numbers of immediate relatives the US government can allow in. So there's no line, so to speak. If the US government gets 2 million applications for immediate relatives and they can actually, approve all of those with their current staffing, then 2 million immediate relatives could come in. So those types of applications are really, the only line is how fast immigration can do the paperwork. But otherwise, people don't have to wait for a visa to become available. All right. US citizens can also sponsor two other kinds of relatives. They can sponsor their siblings and their sons or daughters. So obviously over 21 and or married. But Congress has decided that for some reason, this is a less special relationship. And so they have put limits on the number of visas that are available every fiscal year. And so there are very long lines. So as you can see, if you are a sibling of a US citizen, your wait's going to be, actually, it's pretty much 15 to about 25 years. And if you're the son or daughter, it could be anywhere from 7 or 8 to about 25 years. So why the discrepancy? Because besides setting a visa limit on the number of visas available for this type of relationship, Congress has also decided that there are some countries that are overrepresented in our immigrant pool. And so they have a restricted number of visas. So those countries are Mexico, China, the Philippines, and India. So for instance, if I am the sibling of a US citizen and I'm from France, my wait's going to be 15 years. But if I'm from India, my wait's going to be 25 years. These waits have really, really real life implications. So I'll give you an example. We had a client who was from Pakistan, and he had petitioned for his adult daughters. And they had waited 11 years for their visas to become available after their petitions were approved. So they waited in line, like you hear, people are supposed to do. And then their visa became current. And so we contacted the dad and we said, okay, the girls are ready to come. We need to start the paperwork at the US Embassy in your home country. And, here's a list of things that you need to get to us so that we can send it to the embassy. And so we gave him that list. And 3 weeks later, we got a phone call from one of his daughters telling us that their father had suddenly passed away. And that was it. That was the end. They waited for 11 years and they were never able to come. There's a very limited fix for when the petitioner dies, but in this case, it didn't apply. So, these long waits have enormous implications for families. Right now, we have so many Afghans that are stuck in Afghanistan. And some of them have US citizen siblings here in the United States. I do a monthly clinic down at the mosque in Falls Church, Virginia. And I have just spoken with innumerable Afghans who are desperately trying to get their family members out. And, I'll meet with a brother that was an interpreter for the US government and was able to get out. But he's got another brother that was also an interpreter for the US government that's in hiding in Afghanistan, and he wants to get him out. Well, if he does this, this legal immigration pathway, that brother's going to be waiting at least 15 years to immigrate, and he's going to be trying to stay alive that whole time hiding from the Taliban. So these waits have like incredible implications for people. Life happens, people die, births happen. I mean, the system is a little out of date, shall we say. How do you prove that you're a US citizen? Through your passport, your consular report of birth abroad, your birth certificate, your naturalization certificate, or if you were a lawful permanent resident or a green card holder under the age of 18 and living with a parent who naturalized, you automatically become a citizen, and so you can get a certificate of citizenship. All right, that's US citizenship. That's where we want all of our clients at Just Neighbors to get. But how do they get there? So let's start first with permanent aliens. Again, these are individuals that are here long-term. They never have to renew their status, and they're eligible to work. There are only 3 categories of aliens that fit into that definition, and they are lawful permanent residents, otherwise known as green card holders, asylees, and refugees. So I'll talk about each in turn. So what is a lawful permanent resident? That is somebody who is able to get a green card in one of the 3 ways that was set up by that 1965 Hart-Celler Act. The main way is through family. So a family-based system, still about 70% of the green cards given out every year is through family immigration. And so that's what I was talking about before, US citizens sponsoring family members. Also, green card holders can sponsor people. I'll talk about that in a minute. The second way is through employment-based immigration. These would be, let's say Microsoft doesn't have enough software engineers that are US citizens. So they seek to bring in engineers from outside the United States to work. There are a lot of different kinds of employment visas. And not all of them are actually a pathway to permanency. Some of them are just temporary, but some of our employment-based visas are a pathway to a green card. And about, anywhere from 12 to 15% in any given year of green cards given out are through employment-based. Then there's the humanitarian system, and that is all of the work that Just Neighbors does. So you can see it's a pretty small number of the green cards given out in any given year. But those would be, individuals that Congress has recognized are victims of some sort. And if they qualify for specific humanitarian-based immigration benefits, then they might be able to get a green card. Like employment-based, not all humanitarian-based immigration is a pathway to a green card. Some are, some aren't. I'm going to talk a lot about humanitarian-based immigration later on in the presentation, because that's the work that we do at Just Neighbors, so I want to highlight it. Then there's this teeny little category called the diversity visa lottery. You probably have heard about it. It's a very small percentage of people. It is literally a lottery, and people can apply if they come from a nation that's underrepresented in our immigrant pool. So obviously, if you're from, Mexico or the Philippines or India or China or some other countries, you are precluded from throwing your hat in the ring for the DV lottery. But they give out 50,000 green cards every year, and there's millions of people that apply. So those who win are truly very lucky. And, again, in any given year, there's like about 1 million people that obtain green cards through one of these categories, one of these 4 categories. What are the benefits? Well, lawful permanent residents can work legally. They don't need to have a work permit. They can travel, although their travel is restricted. So they are supposed to make the US their residence. And so they have to stay in the US for a significant period of time every year. So I do have, sometimes we'll get phone calls from people at Dulles Airport who say went home to their home country and either got stuck there or they just spent too much time outside, and they're trying to get back in and they have a green card, but Customs and Border Protection is saying, well, you stayed outside for too long, we're going to take your green card away. And so they literally take the green card away and they serve them a notice to appear and they put them in removal proceedings to take away their lawful immigration status. So, you're not supposed to stay outside the US for too long. And it's generally considered to be 6 months out of 12 months is too long. They may be possible for public benefits. So since 1996, public benefits have been restricted really to US citizens. But after people with green cards are here for about 7 years, they can get public benefits for several years, and then those benefits run out. And like US citizens, lawful permanent residents can sponsor family members, but it's much more restricted, family members. So lawful permanent residents can only sponsor their spouses, their children, so under 21 and unmarried, and their unmarried sons and daughters. So spouses and children is a preference category. When I first started practicing immigration law, the wait was at least 5 years. It is now down to 0 because during the pandemic, all the embassies were closed. And so there's an abundance of visas available now that the embassies have opened back up. So that's the only good side, I think, of the pandemic. But so there's not too much of a wait right now, but that'll go back to being a line that people have to wait in, just like the other preference categories once things ramp back up. And then unmarried sons and daughters, the wait is anywhere from 12 to 21 years. And bear in mind that that son and daughter has to stay unmarried. So if I'm a lawful permanent resident and I sponsor my daughter and she is 22, she's going to have nearly a 20-year wait to immigrate, and she cannot marry that whole time. If she marries, then her petition dies automatically. So again, these rules have very, very real life implications for people. All right, how do you prove you're a lawful permanent resident? You prove it through your card. Now, the card is just proof of status, but it's not the status itself. The card expires after 10 years, but your status doesn't expire. You know, the government just wants us to update our photo and to get your fingerprints taken every 10 years, because you can use your green card status, or really any status, if you commit certain crimes. You can also prove your status through a stamp in your passport or your approval notice. All right, let's turn to asylees. What is an asylee? An asylee is someone who meets the definition of a refugee, but they're here in the United States asking for asylum. Okay, so let's turn to what is a refugee then. It's really the same definition everywhere in the world, more or less. Each nation has tweaked it a little bit, but it's based on 1950 UN definition. And it's somebody who cannot return to their country of nationality because of past persecution or a well-founded fear of future persecution on account of 5 protected grounds. And those protected grounds are their race, their religion, their nationality, their political opinion, or their membership in a particular social group. And that last one is where a lot of the action is, at least for asylees here in the United States. Those could be people who are fleeing from female genital mutilation, LGBTQ individuals, people, domestic violence victims, people who are fleeing from gang violence or cartel violence. Okay. So they have to meet this definition of refugee, but somehow the individual is here in the United States. Maybe they came on a student visa. Maybe they came on a diplomat visa. Maybe they crossed the border without inspection. So they, you know, they're here unlawfully. But regardless, they're here in the United States and they apply for protection within 1 year of entry. All right. Then they have to prove that they qualify for asylum. And while they're waiting, because the wait is very long to be heard in asylum offices or asylum courts, they can get a work permit after their application has been pending. It's actually now 6 months. The Trump administration tried to change that long, but the courts struck that change down. So it's the US government that makes the decision that the individual meets that definition of refugee. And if they agree that they meet that definition, then they award that person asylum. And after the individual has had their asylum status for 1 year, they are eligible to apply for lawful permanent resident status, which we encourage them to do. And within 2 years of the grant, they can also apply for their spouses and minor children. They get, for 7 months, they get public benefits like food stamps and Medicaid while they get their feet on the ground. And then after that, those benefits run out. So, you know, in any given year, we award, you know, anywhere between 20,000 or 50,000 applications for asylum. I'm showing you the 2019 countries: China, Venezuela, Guatemala, El Salvador, Honduras. That is going to change significantly in 2021, 2022, and probably 2023 as Afghans are applying for asylum. So you're going to see Afghan is probably going to be the largest group awarded asylum, followed by possibly Ukraine and maybe Venezuela. So it really, you know, it depends on what's going on in the world, to be honest, who's applying for asylum. Okay, the third group of people, and I should hasten to say that asylees can live in the US forever. They don't have to become lawful permanent residents. We encourage them to do so because it's the pathway to US citizenship, and we really want everybody to become a US citizen. You are in danger of deportation until you become a US citizen. So for lawful permanent residents, asylees, refugees, and everybody else, if you commit certain crimes, and that includes shoplifting, you can be deported. You can also, if you travel back to your country of persecution, you can have your asylum status stripped away and be deported. So They don't have to go. They can remain asylees. They never have to renew their status. They don't need work permits. They're authorized to work instant to status. So they're eligible to stay here permanently. Refugee is the same thing. It's the same definition. The difference between an asylee refugee is that a refugee is outside the United States. So I'm going to use the example of Afghans, because we're really seeing so many.
Dominic, we lost sound. We cannot hear you.
Can you hear me now?
Now we can hear you. Thank you.
Okay. It says my internet connection is unstable. So you'll have to let me know if that happens again.
Okay.
All right. So a refugee is the same thing as an asylee, except that they're outside of the United States. All right. So like an Afghan who has fled to Pakistan, and they register with the UN High Commissioner on Refugees, or the UNHCR, to apply for refugee status. So then it's the UNHCR and not the US government that makes the determination that the individual fits the description and qualifies as a refugee. So that's really one of the only differences between refugees and asylees. It's the same definition, but in one case, it's the US government that is the decider, and the other case, it's the UN High Commissioner on Refugees, that's the decider. So they interview the person just like an asylee would be interviewed in the United States. They do all the background checks, just like the US government would do, fingerprints, whatever. And then they award the person legal refugee status. So you can register with UNHCR and then be waiting for refugee status for a very, very long time before you're actually awarded status. Once you're awarded formal status by UNHCR, then UNHCR begins the very long process of resettlement. And that process can take years. The US government historically has taken in the most refugees of any nation worldwide, but we still take in usually anywhere from 50 to 100,000 a year. During the last presidential administration, that almost was down to zero. All of the Afghans that were brought in under Operation Allied Welcome in the summer of last year were not refugees. They were brought in as parolees. I'll talk a little bit more about that later. But if they are resettled into the United States, then they, within 1 year of their entry, they can also apply for their green card if they want to. Again, they don't have to. They can stay here forever as a refugee. And then within 2 years, they can apply for any spouses or children that were left behind. They are like asylees, eligible to work. They don't need a work permit. And like asylees, they get 7 months of public benefits if they want them upon entry, and then they expire. And like asylees, they cannot travel back to the country of persecution. So I don't know how many refugees we're going to resettle this year. I know Congress authorized, I think, up to 100,000, but the refugee agencies were so decimated under the last administration, and then the Afghan crisis happened, so they're really overworked. So I'm not sure how many refugees we're going to actually end up resettling this year. But to give you an idea, there's, these numbers are from December of 2020. So this does not account for Ukraine and Afghan situation. So they're going to be a lot higher. But as of December of 2020, there were 80 million people forcibly displaced. And of those, 26 were refugees. So they had gone through the process and UNHCR had awarded them refugee status, and they were seeking to be resettled. But the wait in refugee camps is probably close to 10 years at least. Okay, those are people that are here permanently. We're going to now talk about temporary aliens. So there's actually a whole alphabet soup of visas that the US government gives out. Literally, We have A to V as in Victor. So we just have a few more letters of the alphabet if we want to create more visas for people. But A visas are for diplomats, and B visas are for tourists. C visas are for crew members like cruise ship stewards and airline stewards. There's the au pair visa, there's the student visa, there's actually several types of student visas. There's a visa for performers and athletes and all kinds of things. So we have like just an enormous number of visas every year, and I don't even know how many million people come in. Most of them come in as tourists. But I'm going to highlight the humanitarian temporary statuses because that's the work that Just Neighbors does. So I'm going to highlight several categories for you. The first is the Violence Against Women's Act. So what's that? That is a visa for abused spouses or children of either US citizens or lawful permanent residents. So it mimics the family-based system, but Congress recognized that if a US citizen or a lawful permanent resident was abusing their spouse or child, they were unlikely to petition for them. So they provided a mechanism whereby those individuals can self-petition. So taking, for instance, the wife or spouse of a US citizen, they have to prove that they marry in good faith, that they resided with their abuser, that they've been abused either physically or emotionally, and the latter carries a higher standard of proof, and that they're a person of good moral character. So no crimes, basically. And if they prove all that, then they're awarded what we call deferred action status, which is just a promise not to deport. It's like if you imagine status as a ladder with US citizen on the top and undocumented on the bottom, deferred action status would be the first rung. It's just a promise not to deport. And you get a work permit. For most of the people that are awarded VAWA, it's usually a pathway to a green card. Like after they get their deferred action status, I would say probably a good 80% of those people can apply for a green card, but not always. So if they don't qualify for the green card, then they have to just keep renewing their deferred action status every 2 years and their work permit every 2 years. It also covers abused parents of US citizens, and then since June of 2013, same-sex marriages. The U visa, what is a U visa? A U visa is for a victim of certain violent crimes like rape, robbery, felony assaults, who cooperate in the investigation and or prosecution of that crime, and who have suffered substantial harm. So if you're going to apply for that, you have to get a certification from law enforcement that states that you cooperated, and you have to send in proof of all of those elements. But if you are approved, you get a U visa that's valid for 4 years as well as work authorization. After 3 years of having a U visa and living in the United States, you're eligible to apply for a green card. But like VAWA, not everybody gets the green card. And if you don't apply for the green card, then you become undocumented again after 4 years. So it is a temporary status. And you have to take that next step if you qualify to try to get that green card. And like I said, not everybody gets it. The US Congress only allotted 10,000 visas per year. And it's a sad commentary of our culture here in the United States that there's far more than 10,000 immigrant victims of crime every year. And so the wait list is enormously long. Last time I looked, which was several months ago, the wait list was, they had over 165,000 U visa petitions pending. So obviously not all of them are going to get approved. But even say if half of them are going to get approved, it's a 8-year wait for a green card. I'm sorry, for a U visa. And depending on your age and your marital status, you may be able to petition for spouse and children or parents and siblings. All right, a T visa is a trafficking visa. These are available for survivors of severe trafficking, and that's both labor and sex trafficking, who are physically present in the US on account of the trafficking, have complied with reasonable requests for assistance in investigating or prosecuting the trafficking unless they're a minor, and are at risk of suffering extreme hardship if they're removed from the US. All right, I'm not going to go through the definition of what trafficking it is, but it is the federal definition. Like the U visa, the T visa is valid for 4 years, and you get a work authorization for that same period of time. And then you can apply for a green card after you've had the T visa for 3 years. But again, not everybody gets the green card. And if you don't apply for it, then you become undocumented. So again, it is a temporary status, hopefully a pathway to a green card for most of those that get the T visa, but not always. Congress has allotted 5,000 visas per year for trafficking victims. This is underutilized visa. So to my knowledge, immigration has never gotten more than 1,000 applications per year. And like a U visa, depending on your age and your marital status, you may be able to petition for close family members. Special immigrant juvenile status is another temporary status. What's that? That's for children who have been abused, neglected, or abandoned, cannot be reunited with one or both parents, and cannot be returned to their home country. So first, the child and their representative has to go to a family court, like family court in Maryland, and get an order signed by a family court judge stating that they're abused, neglected, or abandoned. They can't be reunited with their parents. They can't be returned to their home country. Once they get that order, then they can apply with immigration for special immigrant juvenile status and prove everything else that they need to prove. They usually can get a work permit after their special immigrant juvenile status is approved. And they are usually eligible to apply for a green card after their special immigrant juvenile status is approved, although there is a wait list, like so many of our visa categories. And so they're in this sort of temporary status while they're waiting to get their lawful permanent resident status, where they have to renew their status and renew their work permits. And if they fail to do so, then they're out of status and they become undocumented again. Interestingly, special immigrant juveniles can never petition for their parents. So let's say they're abused by one parent and the judge awards custody to the other parent. Even that other non-abusive parent can never get status through the child. Temporary protected status. This is when there's been a natural disaster or a civil war in a country, and the US government, specifically Department of State, petitions Department of Homeland Security to say, look, we don't think you should be deporting people back to this country. It's just such a mess. So, you know, can you award nationals from those countries who are living in the United States temporary protected status until things get better? Temporary protected status lasts for 18 months, after which time the Department of State, who usually has people on the ground, provide a report to Department of Homeland Security and say, you know, it's still a mess. We don't think you should deport, or things have gotten better. Yeah, you can go ahead and start deporting again. And if it's the latter, then temporary protected status is terminated. The individual becomes undocumented again if they're in the United States. And if it's re-awarded, then you have to reapply again. So it's a temporary status that lasts for 18 months. It is like deferred action status, just a promise not to deport. You get a work permit for 18 months. If you fail to renew it, then you become undocumented again. Or if your country comes off the list of TPS, you become undocumented again. What are those? What's that list of countries right now? So it's El Salvador and Venezuela, Haiti, Honduras, Nicaragua, Nepal, Somalia, Burma, South Sudan, Syria, Yemen, Sudan, Ukraine, Afghanistan, whoops, and actually Cameroon. I don't have Cameroon on here. That was recently announced. So there's a number of countries on our list. Some of them are earthquakes like Nepal and El Salvador. Some of them are hurricanes like Nicaragua and Honduras. Some of them are civil unrest. You know, most of the other countries are due to civil unrest and civil war. We've had countries like, for instance, we had the Ebola countries on the list for about 3 or 4 years. So we had, you know, like Sierra Leone and Liberia were on the list due to Ebola. And then when that crisis ended, all those people came off the list. So then if they continue to live in the United States, they're now undocumented again. Deferred action status, or DACA. This has been in the news so much. I'm sure you are all familiar with DACA. But this is for the kids who would have qualified for the DREAM Act if Congress had ever passed the DREAM Act. And it's been before Congress at least 14 times by my count, but probably more. So in June of 2012, Obama announced an executive action to grant deferred action status, again, the lowest rung on the ladder, to individuals who entered the country prior to the age of 16, entered the country prior to June 15th, 2007. Were in the United States when Obama made the announcement without status, have graduated from high school, or in high school, have gotten their GED, or, you know, moving towards getting a high school diploma, and have no, you know, serious crimes, no felonies. They're allowed to have only a couple of non-serious misdemeanors like traffic offenses. So you get deferred action status that is good for 2 years. You get a work permit, and then you have to renew it every 2 years. This program has been in litigation forever. So there were 2 different lawsuits going on. There was a lawsuit that was filed by Texas and a bunch of other states initially, like when the program was announced back in 2012, 2013. That litigation is still going through the courts, but recently in 2021, a judge in Texas, a federal judge, ruled that it was an improper program and halted the program, but he is permitting those who had already gotten DACA to renew it while the government tries to fix the issues which he identified. And then they're going to come back and decide if the government has fixed those. If not, DACA is going to go away forever unless circuit court brings it back. So it could be a real disaster for people with DACA status. Then there was litigation because the Trump administration tried to rescind the program in September of 2017. So that litigation went through the court until it finally hit the Supreme Court, which said that the Trump administration had improperly tried to rescind the program and terminated that. So we had a period of time where DACA was open between December of 2020 and, you know, for maybe 6 months, the program was open to people who had never applied for DACA, but somehow met the requirements. And then that loophole was closed again last year when the judge in Texas ruled. And so it's just a mess. I don't know what's going to happen to these kids. It would be great if Congress would pass the DREAM Act. That's the solution to all of this. But there's probably between 600,000 and 800,000 DACA recipients in the United States that have DACA that rely on this, that are, you know, paying into our Social Security system, which for people like me that are getting close to retirement is pretty darn important. So it would really be a disaster to take away their work permits. All right, let's talk about the undocumented. So I just highlighted some people that are here temporarily. There's a lot more categories. There's a lot of workers, you know, migrant farm workers, for example, you know, are another example of temporary status. But there's so many, and we don't have time to highlight them all. But the thing to remember is that not all temporary statuses are an avenue to permanent status. So there's a lot of people that are here legally, but they can never stay here permanently. And they can also violate their status. So let's say you come in as a tourist and you overstay, now you're undocumented. Or let's say you came in as a student, but you had the kind of student visa that doesn't let you work and you started working, now you're undocumented. So how many undocumented are there? Anywhere between 10 and 11 million. About 40 some percent came in legally, but have somehow violated their status, and the other crossed the border illegally. They cannot work. There is no such thing as a work permit for people who are undocumented. Work permits are always tied to specific status. So again, not all people who are here in legal status qualify for a work permit. Tourists are an example. But some temporary status do carry the benefit of a work permit. But people who are undocumented cannot get a work permit. I don't care what you read in the media. People who are undocumented cannot get federal public benefits. There's just no, since 1996, that's been off the table, all right? Some states might give benefits, but no federal public benefits. If they have US citizen children, those children may qualify for food stamps or Medicaid, but the undocumented parent does not. They are deportable at any time. And there are significant bars to them legalizing their status. So when we look at the structure for how people can get status in the United States, again, the state's from 1965. It used to be if you were white, you didn't need anybody to sponsor you. There was no visa process. You literally just came in, and if you could prove that you weren't a criminal or that you weren't going to be become a public charge, that was it. That's all you needed to do. So like my grandmother told me when she came, they had a letter from a cousin saying, well, I'll take care of them if anything happens. And that was how they got around the public charge thing. Now you have to send in taxes and all kinds of things. It's really difficult. But if you were white, the door was wide open. And then in 65, it changed that and it allowed non-whites to come legally, but only through these little teeny doors, like family-based immigration or employment-based immigration. Otherwise, you can't get in. And even if you have somebody to petition for you, there are so many bars to getting that status that it becomes almost impossible if you're undocumented to switch your status to documented. So for instance, let's say I come in and I cross the border illegally and I marry a US citizen and my US citizen spouse wants to apply for me. Well, he or she could do that. But I would have to leave the country to do that process. I can't stay here because I crossed the border illegally. And when I leave, because I've accrued what we call unlawful presence, I'd be barred from re-entering the United States for 10 years. So, you know, if I have a family, why would I take the chance and be apart from my family for 10 years? So I can try to, you know, adjust, so I can try to get a green card 10 years later. So it's incredibly difficult to legalize your status if you're undocumented. And that's why the undocumented population has just not changed too much in, you know, in the last 20 years or more, because those people are stuck. And there's no laws that permit the undocumented to switch their status, even if they have someone to sponsor them, an employer, a family member, based on that 1965 structure.